Welcome back to R.A.I.N. This is part 3 of my video series covering etymology, lawful versus legal, and contracts. In part 2, I left off with explaining the difference between lawful and legal. And I have one more case law to read to you to wrap up the lawful versus legal aspect of this video series. And this is from Penhallow versus Doan's Administrators. Inasmuch as every government is an artificial person, an abstraction, and a creature of the mind only, a government can interface only with other artificial persons. The imaginary, having neither actuality nor substance, is foreclosed from creating and attaining parity with the tangible. The legal manifestation of this is that no government, as well as any law, agency, aspect, court, etc., thereof, can concern itself with anything other than corporate artificial persons and the contracts between them. All right? So all these government entities, they can only interact with other artificial or corporate entities. And that's dealing with contracts. But if you have a driver's license and your so-called name is in all capital letters, that is considered a corporate entity. And let's just say your name is John Smith. And they say, "Are you John Smith?" I'm talking about a government entity. Could be police, could be a judge, could be a magistrate, could be any one of them. They ask you if are you John Smith? They're asking if you are the corporate entity John Smith. If you say yes, then they'll automatically assume jurisdiction over you because you said that you are John Smith, even though they meant the corporate person, but you might be talking about, well, I'm a natural person. You have to state that you are a natural person, and my appellation is John Smith. I am not to be held as surety for the corporate entity in all capital letters that reads John Smith. That's something that you need to know. That's another point for you to study on your own. Or you could just come back to R.A.I.N and I'll cover it in a later video. But moving on. Time to cover contracts. Reading from my book, Who Are You? Knowing Your Ancestors. Page 94. Contracts, contracts, contracts. Everything that you do concerning the colonizer is a contract. As long as they occupy our land, we must keep this concept in mind. There are different contracts that you may encounter but don't realize that you're in a contract. Whenever you order food at a restaurant and you quote unquote pay, that is an implied contract. If you sign paperwork to have a mechanic perform some maintenance or repair work on your car in exchange for quote unquote payment, that is an express contract. What is a contract? Basically, a contract is an agreement between two or more competent parties to perform some action, and consideration may or may not be involved. Contracts deal with law. So I will be quoting several law definitions that you should be aware of. And here is law definition of contract from Black's Law Dictionary, 4th edition. It reads, a promissory agreement between two or more persons that creates, modifies, or destroys a legal relation. An agreement upon sufficient consideration to do or not to do a particular thing. An agreement between two or more parties, preliminary step in making of which is offer by one and acceptance by the other, in which minds of parties meet and concur in understanding of terms. All right. Now we'll go into a criteria for a contract. There's 6 criteria that you must have in order to have a contract in this day and age. All right. Number 1, you must have offer and acceptance. Number 2, written contracts must be producible as evidence. 3, must be a conscious agreement between competent parties, no minors involved. 4, must be agreed upon with free will, no threat, duress, or coercion. 5, cannot be vague, unclear, or have anything that is not ascertainable. And 6, must have valid signatures of all parties involved. All right? That's your criteria for contracts. Let me continue on with this book. Most contracts that people experience on a daily basis are express or implied, but there are many more types of contracts. Please refer to Black's Law Dictionary, 4th edition, for the many different contracts and their respective meanings. For now, here is the definition of express and implied contracts from Black's Law Dictionary, 4th edition. An express contract is an actual agreement of the parties, the terms of which are openly uttered or declared at the time of making it, being stated in distinct and explicit language. An implied contract is one not created or evidenced by an explicit agreement. Otherwise, there is no written agreement. Explicit agreement of the parties, but inferred by the law as a matter of reason and justice from their acts or conduct, the circumstances surrounding the transaction making it a reasonable or even a necessary assumption that a contract existed between them by tacit understanding. And that goes back to my original example of a natural person going into a restaurant and ordering food. That is an implied contract. There is no written agreement or anything like that. You order the food, you quote unquote pay for the food, and you receive the food that you ordered. That is an implied contract. All right? That concludes part 3 of this video series covering etymology, lawful versus legal, and contracts. I will be back for part 4, and it will be explicitly about contracts. Nothing else. Alright? Peace.